Yes, Mr. Dratwell.
My Lord, I was finishing the submissions on section 1771A, and can I do so by taking your Lordship's back to the Court of Appeal judgment? I think that's where I was immediately before lunch. And to the reasoning of Lord Justice Etherton, and just to pick up some short points on this, your Lordship goes, it's actually page 10, Roman 3, paragraph 26 of the appendix.
Yes.
Well, the last part of paragraph 26 contains a statement about the scope of the possibility that the code might alter the meaning of section 1771, and I respectfully adopt that. It's plainly correct that guidance under section 182 can't make provision that says, that effectively defines the meaning of the words violence and domestic violence. This may be a sensible point to make one small subsidiary submission. Insofar as we are considering the possibility of orders under section 177 subsection 3, those orders are subject to the negative resolution procedure by virtue of, I think, section 145. There's a footnote to 1773 which tells precisely that, I think. Yes. It's section 215.
So where are we looking?
Well, if your Lordships actually want to look, we are now looking at section 177 in tab 5. Yep. The point I'm making is just a general point that if your Lordships go to the, footnotes, about 6 lines up from the bottom, as to orders under this part of this Act, generally see section 215.
Subsection 4.
Yeah.
Subsection 4 is of 215.
Of 215, yes, of 215.
Yes.
Yes, sorry.
Yes, I'm sorry, it's not, I haven't found a subsection
yes,
2.
Yes, it is.
Sorry.
Yes, it is subsection
Yes.
4, indeed. And so subject to negative resolution procedure. There's a mini constitutional point about the relationship with the code there. If your Lordships were with me, that as originally enacted, the 1996 Act and the 2002 amendments envisaged violence being physical violence, any argument that the code, as opposed to the living instrument doctrine, the code itself produced a different result, will be circumventing the negative resolution.
You're muttering, you are, Mr.
Oh, sorry.
I'm terribly sorry, but you must speak
I will
up.
speak into the... There's a mini constitutional point that if the argument is, which I don't think it is, that the enactment of the new code alters the meaning of section 1771 as amended by section 14 of the 2002 Act, that would circumvent the parliamentary control over orders extending the classes to which the provisions applied.
Well, I didn't understand.
No, I think I'm treating it a dead target.
It's put as guidance only, no more, as I understand it.
Yeah, and I think yes, exactly. But
Persuasive.
It was original. I'll keep quiet any further because I don't think the argument is going any more than that. Going back to the judgment, paragraph 31 is, as I understand it, Lord Justice Etherton making our point on the structure of 1771 and in particular 177 1A, which I have already adopted and do adopt now. And then finally, paragraph 32, is Lord Justice Atherton saying if there is going to be a change, it ought to be done in a considered way under an order, in an order under section 1773. And that plainly, again, is a submission that I repeat. Well, those are my submissions on the construction of the actual text of 1771 as it now stands.
Yes.
Our case deals with the legislative history, and if I can just deal with that as shortly as I can, although it is of some importance to our case. If your Lordship has our case open at paragraph 11, page 7 of the case, the starting point is the provisions that Miss Leaven took your Lordships to before lunch, namely section 1 of the 1977 Act. We have seen section 1(2)(b). My submission, unsurprisingly, is that the formulation in 1772(b), it is probable that occupation of it will lead to violence from some other person residing in it, or to threats of violence from some other person residing in it and likely to carry out the threats. The natural meaning of the word violence in those contexts is actual physical violence, and I repeat the submission that the concept of threats of violence is very much easier to apply if one is dealing with actual violence. It is entirely correct that, as we saw before lunch, in section 5(1)(3), there is a reference to domestic violence. Section 5, subsection 1(a)(3). And the definition of what is contemplated by a person running the risk of domestic violence in subsection 11. Repeat the submission that the structure of subsection 11 envisages that the violence is actual physical violence, all the points we've made already.
I mean, this is a concept in terms of being returned from Kensington, Chelsea to Swansea in that other case. The risk of suffering domestic violence, ex hypothesi, you're now separated, you're entitled to be rehoused separately, the full duty has arisen.
Yes.
But this takes you, does it, to the 6.18 advice in the 2002 business about it extends to violence outside the home from a person with whom the applicant or a member of his family is associated. So you might be sent back, and there it is, your son is living in your abusive, your violent son or husband or whoever it is living somewhere down the road, and he might come and attack you in your own house or whatever, or meet you in the street or whatever.
That's exactly the concept. And I'll go to the code shortly. Yeah. But the point I want to make just now is that this is the provision that became section 198 and is construed by Lord Justice Newberger, as he was in the case that your Lordship has just referred to.
Yeah.
And I think I do say that the structure of the insertions into section 198 by the 2002 Act into 198 envisage actual violence in exactly the same way as I say the insertions into section 1771 large A do in section 177 context. So our case is that all the way through this legislative history, the drafting assumption has been that violence is actual physical violence, and that continues right up until 2002, because it's the 2002 Act that inserts 1A and whatever the provision is that's inserted into section 198 and was construed by Lord Justice Newberger. They march, as everyone agrees, hand in hand. And so we do say that the legislative drafting assumption is that violence is actual physical violence continued until the latest amendment. I think that's enough for the 1977 Act. Then, as we say at the end of paragraph 11 of the case, next step is the enactment of section 58(3)(b) of the Housing Act 1985, which we needn't spend a lot of time on. It was an entirely consolidating statute and repeats the same formulations.
This is a Consolidation Act, wasn't
It is indeed.
Yes.
Yes. Then we have Pulhofer. Then we have tab 3, the insertion following Pulhofer into the 1985 Act of section 2 large a and section 2 large b by section 14 of the 1986 Act.
So your paragraph 13 suggests that there was a narrowing under the legislation until 2002.
13, I missed one feature, one important feature of the statute.
Is your 13 wrong?
Yeah, yes. Can I just explain exactly why? It's only partly wrong, but it is wrong. If you go back to section 1 of the 77 Act, (1)(2)(b), the identity of the perpetrator of the violence was that it was some other person residing in it. So there's no limitation of the class of people residing in it. It doesn't need to be a partner or relative or anything of that sort, anybody residing in the property. But they do need to be residing in the property. By the time you get to the 96 Act, the limitation that the person has to be residing in the property has gone.
Yes.
But the perpetrator does need to be a person with whom the dweller is associated, the tenant or whoever it is associated. I'm afraid I realised the second point and missed the first, so that's why.
Sorry, I'm not.
If your Lordship looks at 1771 as originally enacted at tab 4,
Yeah.
Yes.
for this purpose, domestic violence in relation to a person means violence from a person with whom he is associated. So no requirement that he's living in the dwelling, so that part of the section of the 1977 Act and the 85 Act has disappeared. But a new requirement that the person is associated is inserted, and there's a definition of associated person in 178. So my paragraph 13 is wrong by important omission, and I accept that.
And that's to cater, of course, for the former partner who
Yes.
keeps
Might
coming
come
back and
Yes, exactly right. Yeah.
in the bond situation, in fact.
Yes. Yes. And then you get the further extension, about which we know no more than what is said in the 2002 code, to where the violence didn't need to come from an associated person at all. But going back to my printed case, I make the point, which I ask the court to bear in mind as part of the background, that it's only at the moment in time when the 1986 Act is enacted, second half of paragraph 12 I'm now referring to, that the present shape of the legislation emerges.
Yes.
And it's only at that point that the 58, what was then the section 58(3)(b) provision, either redeeming or becomes truly either redeeming or passporting provision, because that concept doesn't really bear the same meaning until we have the 1986 Act.
86.
Yes, 86 Act amendments. It's the post-Pulhofer amendments.
And they're inserting into the 1985 Act.
Exactly. The 1985 Act is enacted.
Yes.
I'm not sure the exact order of Pulhofer and the 85 Act, but when the 85 Act is amended, then the significance of Pulhofer dawns. It reverses the department's then understanding of the position. It's reversed by both 2A and 2B in section 58.
Yes.
And it's only at that point that you get the relationship between a provision treating accommodation as not available if it's not reasonable for the tenant to continue to occupy, together with the existing provision in section 58(3)(b), which becomes a deeming and passporting provision and also takes the victim of domestic violence out of the need to consider section 2B, general circumstances of housing in the area. One does wonder whether one hadn't had this precise legislative history, whether we would have had a deeming provision in quite this form anyway. I'm not sure where that goes, but there it is. My Lord, so we've seen the 1986 amendments, then we have a tab 4, the text of section 177 as enacted. Repeat the submission that I'm sure your Lordship and my Lady appreciate I'm making, that even in the 1771 form as originally enacted, the fallout words to 1771 mean where violence means violence from a person with whom he is associated or threats of violence from such a person which are likely to be carried out, that the natural meaning of that is actual physical violence.
There's a fairly obvious rewriting of the original consolidated provision, though, isn't there? The thing is being reorganised, as I understand it, in the new section.
Yes.
Although you're right to point out the words are the same, although in a different order.
Yes. There's obviously a physical, I completely agree, there's a reordering of the section.
Yes.
But we have a position where I can make the submission on the face of 1771 in its original form, that effectively violence is defined in a way which strongly suggests that what was being talked about was actual physical violence. And then I make the point that when one goes on to 1771 large A, as inserted by the 2002 Act, it's obvious that the draftsman continued to share that view for all the reasons I've already explored. So we make the submission, input the final bit of paragraph 14 of our printed case, that the author of the code and the draftsman of the amendments both contemplated that domestic violence in this context meant physical violence. It's a code, which I'll go to in a moment, walks hand in hand with the insertion of subsection 1 large A. Now, those are our submissions on the evolution of the statutory scheme. Next task is to take your Lordship and my Lady shortly to the codes. The 1977 code is tab 9. My submission is on a fair reading of the code as a whole. It was apparent that the draftsman contemplated that violence was physical violence.
Where do we find that?
Tab 9.
I know, but which bit
Sorry,
of it?
I'll ask you, I was going to draw your lordship first of all to 210B. Your lordship and the lady can read that. It's not conclusive, but it certainly doesn't suggest that the draftsman was contemplating any extended approach to domestic violence. There are other passages which are, I submit, indicative of the general approach behind the drafting of the 77 Act. If your lordship looks at over the page, it's in paragraph 212, and it's actually dealing with people in priority need. Your lordship will see about 8 lines in a reference to one-parent families, including battered women with their children. So the natural language that the draftsman used to describe women who've been driven out of the home by, presumably, by violence within the meaning of section 1.2a was battered women. And if your lordships and the lady goes down the page to Romans 3, it's 212c3. Same flavour comes out of this. 2 lines into Romans 3. In particular, the Secretaries of State considers it would be appropriate under this heading for authorities to secure wherever possible that accommodation is available for battered women without children who are at risk of violent pursuit, or, if they return home, at risk of further violence. And that concept of violent pursuit in our submission reads like a threat of actual physical violence, and that corresponds with the language of what was the section 5 at the time of the 1977 Act, and what is now section 198 as construed by Lord Justice Neuberger. So that's the 77 code. The 96 code has a section on domestic violence at page 55 of the document. This is tab 11.
Page number?
Page 55, paragraph 1310.
Yes.
Any point in looking at the 1991 code?
Page 9.
What happened with the 1991 code? This is
I don't know whether there is or there isn't. I haven't read the whole way through it.
there's a 5.8D.
Well, wait.
5.8D was what
Racial
rather,
harassment.
leapt out of the page at
Yes.
me.
So this is the
1991.
Code.
It's
how do we know
indeed.
it's 1991?
It's talking about violence or threats of violence from outside the home.
Yes.
But it says violence or threats of violence could include racial harassment or attacks, violence against a person, sexual abuse or harassment, and harassment on the grounds of religious creed.
Yes, but your ladyship is entirely correct, but it's under the heading, when is it reasonable to continue to occupy accommodation? But it's not dealing with the deeming, or what I call the deeming provision.
Well, there wasn't a deeming provision then.
But it is,
Well, there was. No, there was. By this stage, where in the post-Kulhofer, there isn't 1771B, but there is section 58.3B.
Sorry, I'm getting my chronology wrong. I'm so sorry. However, all I'm saying is it's
Yeah.
dealing with violence
No,
and it's contemplating a wider definition of violence.
yes. I say it positively helps me because under the heading it is dealing, as your ladyship will see from paragraph 5.7, so section 14.2 of the 1986 Act inserted two subsections into section 58. Those include the post-Pulhofer reasonableness provision, and 5.8 is dealing with that.
Yes?
So that what it is not doing is telling you that the statutory test of violence it includes harassment short of actual violence. There is a provision dealing with what I call the deeming provision in paragraph 5.9 of this code at page 18.
Just we come back to the same phrase, violence and threats of violence.
It's using the word violence, and it isn't the same demon provision.
But it's using it in a rather different way.
Yes.
I mean,
Once the post-Pulhofer scheme emerges, in a sense that's inevitable because you've got to actually apply the statutory language of 58.3b, and then you've got to look, in my submission, at a wider range of factors in order to see whether or not the 58.2 large A test is satisfied. I completely accept that in describing that wider range of factors, the draftsman of the code has described harassment as violence. I can't get away from that.
That was the only point I was seeking to make.
Yes,
It does rather indicate that in 1991, the word violence was understood in a rather wider sense.
Could be understood in a yes.
May not, may not help one or
I
the
mean,
other.
I'm going to make this later, but it's probably a convenient time to make it now. I'm fully aware of the point that can be made against me that if one looks at the matter chronologically, there is a widening perception from well before the enactment of the 2002 Act that domestic violence, the phrase domestic violence, would often encompass psychological abuse. My submission is that when one comes to the language of the 2002 Act, it will be startling if the draftsman had intended to include that wider approach. If he had, he would just simply never have used the language of 1A. He has stayed with the drafting assumption that's present all the way through the legislative history, that in the context of the deeming provision, violence means actual violence.
Well, shall we look at the next code, which is the 1996 code, and it was page 54, 55, you asked us to look at.
It's 50. The most relevant paragraph is well, I think it probably the most relevant paragraph is 1310.
Yeah, there are bits to pick up on the opposite page.
And the same points
Yes.
that we've just been exploring in relation to the
Absolutely.
earlier code,
Yes,
I think, in essence.
yes.
I mean, basically, the actual draftsman of the code has been, you say, less careful than the draftsman of the statute, but has used violence in both senses.
Yeah.
But in fact, in different contexts. One, the wider one, to deal with the general unreasonableness to require them to go back, but more narrowly in the deeming provision.
Yes.
Yeah.
It's a fairly sharp point, that last point, because if it's right that by the 2002 there was a wide and generally accepted meaning of domestic violence, which is the one contended for by those appearing against me, one simply wouldn't have expected 1A to be structured in the way in which it is structured, 1 large A to be structured in the way in which it's structured. And indeed, I'm entitled to say that one reason for the acceptability of that is that violence in a wider sense could be taken into account, and the code is telling you it can be taken into account at the earlier stage.
And would you, perhaps I'm jumping ahead a little bit, would you, when we come to the phrases in section 198, would you accept that they would be construed in the wider sense?
No.
No.
No. They are deliberately drafted to get at the concept of what the first code called violent pursuit. I mean, the structural point on 198 is whatever insertion there is into 198 by the 2002 Act is as forceful in that context as it is in relation to the to Section 177. The adverse consequence of that, from my stance, is that you can't make an order under altering that position under 198.
Yes.
But I'm still entitled to say that the draftsman thought it was acceptable in 2002. That's what he did. And
well, time is running on a little bit. Shall we go to the next code? Is there anything else on 13.9 and 10?
Next one is the 2002 code. That deals with domestic violence, paragraph 616 and 618 and 619. I understand Ms. Leaven and I think Mr. Lurici both say that this language is neutral, in the sense that it simply paraphrases the statute. That is true. But of course, I have my submission that the statute isn't neutral. But if one then goes on to paragraph 826, my submission, if one reads the language of 826 as a whole,
yes, racially motivated.
yeah, motivated violence or threats of violence likely to be carried out, we are dealing again with actual violence. That becomes even clearer if one contrasts it with 832 over the page,
Yes.
which is one of the provisions relied on by Lord Justice Neuberger.
Well, it rather addresses a point non-violent.
Yes, exactly. It does it pretty head on in this case.
Yeah. Yes.
So we say, with respect, that Lord Justice Neuberger was entirely right to say his approach was fortified by the 2002 code, pretty well contemporaneous with the 2002 amendments. Those are the points on the code.
Anything on the 2006 code you want to say?
Well, no, I of course accept that there has been the change which is identified by the appellant.
Yes.
Though it's interesting that 832 seems to appear in identical words in 834 in the 2006 code. It's still talking about non-violent forms of harassment.
Yeah.
832.
Yes.
Yes.
Now, I have one further heading of submission, which I hope I can finish in the next 5 minutes, which is my agreed slot, which is the need, what I've called for the purpose of this submission, the need for precision.
Yes.
Because in our submission, both the appellant, the Secretary of State, and Women's Aid, all of the three, have failed to provide anything resembling a working test that this court can hold as a matter of statutory construction is what should be applied by a housing officer applying section 1771. And the simplest way of making this submission is to go to an authority that the appellant relies quite strongly on, which is AN Pakistan, the judgment of Lord Justice Richard. Sorry, I'm trying to pick up the reference as well. I think it's on tab 13. No, sorry. Tab 17, I'm good.
So it's volume 2, 17.
Volume 2, tab 17. First point on AN Pakistan is that in a way the threshold problem doesn't arise in anything resembling the same way that arises in the present case. That is because of the structure of the relevant immigration rule, which Your Lordship and the Lady have already seen, paragraph 2 of the judgment. There is a clear target because you satisfy paragraph 289A if, inter alia, and then it's C, you are able to produce such evidence as may be required by the Secretary of State to establish that the relationship was caused to permanently break down before the end of that period as a result of domestic violence. So here, the domestic violence that's required is one which has in fact produced a breakdown of the relationship.
Yes.
So you don't have the same threshold problem. My learned friend relies upon the observation in paragraph 24 that the violence to qualify under that rule must reach some minimum level of seriousness. That's the first sentence. Now, doing the best I can to understand what is the case against me on the test that is to be applied, as I understand it, this Leaven's approach is to look at the various definitions of domestic violence that are either in the code or are set out in the judgment in AM Pakistan, paragraph 20, any form of physical, sexual or emotional abuse which takes place within the context of a close relationship. Or over the page, any incident of threatening behaviour, violence or abuse, psychological, physical, sexual, financial or emotional, between adults, etc. And then to say, if you have abuse which is psychological, physical, sexual, financial or emotional, which crosses a minimum level of seriousness, then the test is, as I understand the submission, satisfied. It will no doubt produce the same result if you use the range of concepts that's in the draft of the 2006 code. A similar set of forms of abuse, provided they exist to a minimum level of seriousness, and the test is satisfied. My submission is that that would produce a quite hopeless test with respect for the housing officer to apply.
It's a what?
A hopeless test was the adjective. Not workable test for the housing officer to apply. And the same is true, in my respectful submission, of Mr. Nafler's and Mr. Marici's approach to the same problem. They certainly haven't suggested, Mr. Nafler says there shouldn't be a threshold, and Mr. Marici doesn't suggest anything other than the minimum level of seriousness.
Does controlling, which is the word that was used frequently in the Women's Aid one with its interpretation in that footnote, is that not itself demonstrating or suggesting that a level of seriousness has been reached? Because the odd instances of abuse and so on, and shouting and so on, wouldn't really achieve what would be necessary to be judged controlling behaviour.
Well,
but if you reach the view that controlling behaviour is what it is reasonable to expect the person to have to face if she remains where she is, then itself, does that not give you a level?
well, as I think I said in the case, the problem that learned friends all have is that you can't possibly answer the threshold test by simply asking the question, is the abuse of such a kind as to render it unreasonable to continue to live in the property? Because that's just the 1753 test.
Yeah.
The deeming provision's doing nothing if that's the approach. So for the deeming provision to have any meaning at all, you've got to get in between the 1753 test and some acceptable threshold.
What was the, I mean, Mr. Drummond, what about the Law Commission report?
Well, that's what I've got. That's my final submission. The alternative is the one canvassed by Baroness Hale very early on,
Yeah.
which is to go to the Law Commission report, which we find in the...
We've got the
Well, we've
definition.
got it actually quite neatly set
Oh,
out
have we?
by Women's Aid in paragraph,
Women's Aid, paragraph
page 24.
That's what I was going to go to.
Yes, I think that's...
Page 24, paragraph 62.
We're in the second intervener's
In the
case.
second intervener's case, that the alternative to the very low threshold that's being suggested by all three counsel would be a test expressed in terms of psychological molestation or harassment which has a serious detrimental effect upon health and well-being of the victim. Now, I think here we come back to what is the role of the deeming provision. If you get to a stage where the person who says, I can't live in the property because of the abusive behaviour of my partner, here is the psychiatric evidence which shows that this has a serious detrimental effect upon health and well-being of the victim, then that would lead a housing authority in my submission to conclude that it was unreasonable to continue to occupy the premises, at least unless the remedies available in the family court were offered sufficient protection. That's the 1753 test. So once you get the threshold that high, the deeming provision isn't playing much of a role at all.
Well, it is achieving, getting around subsection 2, isn't it?
Yeah, it is doing that, but in my submission, the prospect of subsection 2 playing much of a role, that is, a housing officer coming to a decision that it is you are and will in the future be exposed to psychological molestation which will have a serious detrimental effect upon your health and well-being, but you have to continue to live there because of the general availability of housing stock in the area, is pretty remote. So the obvious target of subsection 2, with respect, is quality of housing stock. And that's what it's for. That was the Pulhofer problem.
Sorry, 1772 was designed for
It was a design.
low quality housing.
Yes. I mean, the Pulhofer problem was that, is it Lord Bridge or Lord Brightman? I've forgotten which it is. In Pulhofer,
Or Brightman.
Brightman.
Lord Brightman said you could live in a tub, didn't
Exactly
he? I
right.
think? Yeah.
And the review up to then was that you would look at whether it was reasonable for you, I mean, just as a matter of construction of subsection 1 of section 58, or whether it was reasonable for you to continue to live in the property. And inherent in that will be an issue of where else you might reasonably be expected to live. So once you insert back in the reasonableness concept, then you have subsection 2, too large B. Now, I'm not suggesting that it plays no part in domestic violence cases, but once you have got a high threshold, such as that suggested by the Law Commission report, then in my submission it is unlikely that subsection 2B will play a major role in the decision-making process.
Why does it say not apply to ordinary violence? It's not the same argument.
Well,
I think that's the point which was made against you on that. I mean, the same could be said, couldn't it, Mr. Brown?
It is undoubtedly the case that the wording of the domestic violence provision requires the authority to deem it to be unreasonable on demonstration of actual violence.
And what purpose does that serve, on your argument?
The effect is to exempt you from subsection 2. Subsection 2. The purpose is presumably to avoid complicated investigations and inquiries. But that's absolutely what is not happening on the approach of any of of those against me.
Well,
I have reached my time. Whether I've given the right answer, I don't know, but those are my submissions.
well, thank you very much for your assistance. Mr. Feldman, do you wish to add anything? Thank you. Ms. Leighton.
My lords, my lady, can I start with the last aspect, which was also the first aspect of my learned friend's submissions, which is what's the role of this deeming provision and is it necessary? As I understand Mr. Drabble's submissions, they really come down to him saying that it doesn't matter if the victim of domestic violence can't rely on section 177(1 because the victim of psychological abuse, which he accepts could be domestic violence on any normal meaning, can be protected by section 175(3 in any event. And he points to the facts of Mrs. Yemshaw's case to say, well, she didn't satisfy the housing officer that it wasn't reasonable for her to continue to occupy. And in that situation, he said this morning, well, why should she be entitled to housing through the deeming provision of section 177(1 or passporting provision? But in my submission, that analysis robs section 177(1 of its effect, and it ignores the reality of domestic violence. If in cases of domestic violence, whether physical or psychological, the victim could simply go to the housing officer and say, it's not reasonable for me to continue to occupy because my partner has either hit me or psychologically abused me, then Parliament would never have needed the passporting provision. The reality of domestic violence is that that is a very difficult situation for the housing officer to deal with, and the evidence that led Parliament to put in the passporting provision was that there were particular issues, well known to my Lady Hale, particular issues around victims of domestic violence who needed a special level of protection, and couldn't therefore be expected to simply rely on section 175(3. That's the point made and accepted by both counsel in the Bond case. And the kind of difficulties which your lordships will see throughout the background policy material in this case is that domestic violence happens behind closed doors, generally in private, often with no witnesses. It induces a sense of powerlessness and shame on the victims, which make it difficult for the victims to report, difficult for the victims to produce concrete evidence, and often very difficult for the housing officer, and this is probably the most critical point, to understand the impact of the behaviour, both on the victim and often on her children. And to some degree, examples of that have been given today in this hearing. So one approach of a housing officer in physical violence cases may be, oh, well, it was only a few slaps. What are you worried about? Might not happen again. A lack of understanding of the impact that that can have on a woman. Or, in my submission, perhaps unsurprisingly, my Lady Hale pointed to probably the best possible example of psychological abuse, which is a husband saying, or a partner saying, I'm going to take away the children. Now, even if the housing officer may easily take the view, but that wasn't a real threat, the family court would never support that, you don't need to worry about it. The point is that the housing officer's perception may find it very difficult to understand the impact that that conduct has and why that affects the woman's ability to continue to occupy. Of course, if you had every housing officer was sympathetic, fully trained in domestic violence and all its ramifications, and omniscient in his or her decision-making, maybe you wouldn't need section 177(1). But the fact is, Parliament took the view that because of the particular issues around domestic violence, and those particular issues arise just as much in the context of psychological violence, you do need section 177(1). So in my submission, Mr Drabble's approach robs it of its fundamental purpose. Very briefly on the other aspect of section 177(1), which is taking the person out of 177(2), in my submission, section 177(2) is not limited only to the quality of housing, and therefore only relevant in cases where one's arguing about things like overcrowding. It is also relevant to the quantum of housing. So if a victim of domestic violence isn't immune to the effect of 1772, she may well face the argument, well, all right, there has been some domestic violence, but overall, given the fact we haven't got much housing, we still think it's reasonable for you to occupy. The point is that if she falls within 177(1), she doesn't have to face that argument. And in my submission, the facts of this case show precisely the kind of problems that happen in reality to a victim of domestic violence such as Mrs Yemshaw. If one looks very briefly at part 1 of the appendix on the facts, and go back to the review decision of the council that Mr Drabble took you through at some length this morning, it's perfectly clear, I'm not going to read through it again, that the reviewing officers focused entirely on physical violence. Was there physical violence? Was there likely to be physical violence in the future? And when they considered page 41, was Mrs Yemshaw frightened? There's a paragraph 1, 2, 3, 4 from the bottom. We did not ignore the fact that you stated to Mr Wilson that you're scared, but when asked to clarify why you were unable to substantiate this point, and stated he's not a violent person and will not use physical abuse because he does not want to be arrested. So the housing officer is looking at fear of the victim entirely in the way that, with respect, my Lord Brown suggested this morning, it's only genuine fear if you're afraid he's going to hit you. And as my Lord Roger was quick to point out, that is clearly not covering the gamut of situations that arise with domestic abuse and domestic violence. And one can see that, and I'm not entirely sure whether your lordships, I think my lady has it, in the appendix part 2, where you see the interview notes. Oh, I'm very grateful your lordships do have it.
Yes,
you see there the interview notes, and you get a very different picture of what my client was complaining about from that in Hounslow's review decision. Page 120, the handwritten review notes. I'll just pick out a few passages.
Is that tab 18? Yes, it is. I think.
I don't have tabs on
well, it is. It's handwritten anyway, yes.
Tab 18, it's notes of the interview, and this is the closest one gets to my client's actual words and concerns. Left-hand page 120, second full paragraph. Applicant's husband shouts in front of the children. Applicant has to retreat in the bedroom. Shouting has been going on for about 6 months since birth of their child. Applicant has no friends, relatives, was in hospital for 3 days.
Alone in hospital?
Alone in hospital for 3 days. Yes, I think alone's twice. Yes. Husband does not treat her like a human. He does not help her look after the children. Applicant does not get any sleep. Applicant's husband sleeps in another room. And then over the page, applicant is scared that she will lose the children, that he will take them away. He's been saying to her that she is depressed, and she is scared that he will say she is not capable of looking after the children. Then applicant doesn't know how to look for her own property, doesn't have the time, or she's looking after her children all day. Applicant cannot give specific times or examples. Only when she gave birth, she phoned him, and she said he said it was her responsibility to give birth and she should do it alone. Another time he shouted at her about her cooking. Another time came home drunk and shouted about the door being locked. But then when we come over the page to the officer's advice, applicant advised to look for private rent and go back to her husband in property meanwhile. Applicant does not want to do this, but it was explained to her that she is not homeless, as from what she has said, there is not any evidence that her husband will hurt her
Yes.
if she returns. So it's an absolute classic situation of the
To be fair, I think Mr Drabble does accept that this was the approach that they were using.
Yes, but the point I seek to make, my lady, is that if one translates what the client is saying to how the reviewing officers reviewed it, you can see in my submission why one needs section 177(1).
So what would we do if we were with you, Miss Lady?
You're asking us
I'm
to
sorry,
remit,
my lord.
aren't you?
What would you ask, what would we do?
Well, what you would do on the facts of this case is say that domestic violence within section 177(1) includes psychological abuse. And you would say that Hounslow should revisit its decision,
Reconsider.
make it again, yes, having properly considered that evidence.
So it's rather, yes, so it's reconsideration.
It's a reconsideration, yes. Sorry, my lords. Mr Drabble submits that it doesn't matter that there's an inconsistency, could be an inconsistency between section 177 and section 198 if the Secretary of State makes an order under section 177(3, because he says that the primary duty owed is under section 175 and where passported 177. So it's all right if one would end up with a situation where, although a psychological abuse was accepted as a category within section 177(1), a woman could still be sent back to the area where the abuser lived under section 198. And in my submission, that inconsistency would be totally unacceptable and completely contrary to the policy of the Act. Because I think Mr Drabble suggested, well, by that stage, the woman and the man will be living separately anyway. But that ignores the kind of problem that arose in Bond, where the husband was coming round, sitting outside, throwing stones and shouting abuse. To be the victim of domestic violence, it is quite possible that the partner, maybe an ex-partner, and maybe outside the house. So to end up with a situation where you have a wider definition in 171 because of the 177 because of the deeming provision. I'm sorry, I'm losing the plot. To end up with a situation where one has a wider definition in section 177(1 because the Secretary of State has exercised his power in 177(3 for the wider definition, or the wider scope, but that isn't taken over to section 198, is completely illogical. Then can I just tear through my other points? Legislative history, it may be of relevance for your lordships to know that the 1977 Act was a private member's bill, and it was only in 1996 that the parliamentary draftsman got his hands properly on putting the scheme together in its present form. One does get some suggestion in my submission as to the thinking behind the 1996 Act in the Home Affairs Select Committee report. I've already referred to that once, but if I can ask your lordships quickly to go to volume 9.
Do we get the quotation in Women's Aid?
No, it's
We
a
don't.
different point,
A
my
different
lord.
thing, right,
It's
thank you.
volume 9, section 83,
Yeah.
paragraph 131.
Yeah.
And there, the Home Affairs Select Committee is expressly dealing with intentional homelessness and the problems that arise when women escaping domestic violence are found to be intentionally homeless. And the Home Affairs Committee asks the relevant government departments to consider those issues and move forward on them. And that's relevant because, of course, the Home Affairs Committee was accepting a definition in 1993 which included psychological abuse.
Which paragraph were we?
131, my lord.
131, yes.
That's where they deal with, this is in a section about housing,
Yeah.
and that's the section which I suspect, and I can only guess, but I suspect that section then, well, that recommendation then moved to the relevant government departments, which at that stage was the Minister for Housing and Planning. Further reports were carried out, and then we come forward with the 1996 Act.
Yes.
In respect to the codes and the statutory definitions, I obviously don't have time to go back through the legislation, but in my submission, the highest one can put it is that going back to 1977, neither the statutes nor the code expressly say one way or the other whether or the extent of violence and then domestic violence. One can put some weight, but I'm happy to accept only limited weight, that it's clear that from at least 1991, the authors of the code thought that violence was not a concept limited to physical violence. But in my submission, my learned friend keeps saying, if you go back to 1977, it is clear that Parliament thought violence was physical violence. But in my submission, you can't draw that assumption from the words of the statute. They're silent on the issue. And then finally, on definitions, my lords, in my submission, there is a choice of definitions which are workable. There is the Law Commission report, there is the government definition, and there is the earlier definition in AN Pakistan. All of them include psychological abuse, and all of them are workable. And in my submission, my learned friend's argument that these are, I have not suggested a working test, is simply wrong, because we know that under the immigration rules, there is a working test which includes psychological abuse. And the immigration officers have to exercise it on a day-by-day basis. So I don't understand rhetorically how my learned friend can say it isn't a working rule, working definition. It's right to say that in the immigration rules there is also a causative test. Yes. So you've got to have domestic violence, and it's got to have led to relationship breakdown. But in judging whether there's been domestic violence of a sufficient severity, which was the AN Pakistan point, immigration officers are using that test all the time. And the courts have not been bombarded with cases where the immigration officers are finding it impossible to apply. Equally, the respondent themselves, Hounslow, have guidance which applies that test, and there's no suggestion that they find it impossible to apply. I would just say on Mr. Nafler's intentionality test that in my submission that does create a level of additional level of complexity which is not necessary. It isn't going to be easy for a housing officer to determine what the intention of the abuser was. It may be, Mr. Nafler may be entirely right that in many, many cases it is about control. But in my submission, one doesn't need that element, and it's just making life more complicated than it needs to be. And it is important to bear in mind, because in my submission, Women's Aid's case is coming from a particular perspective, that domestic violence in the statute is not limited to partner or ex-partner violence. It's not just that it clearly covers homosexual couples, but it would also cover non-partner violence. And then just finally, on my Lord Rogers' question about the abusive neighbour. In my submission, abuse from a neighbour could amount to psychological abuse, but it's important to bear in mind that it is much less likely to do so, because the psychological effect of domestic violence is a lot to do with the fact that it's taking place in a domestic context. No. And also in an intimate relationship. So it would, as a matter of fact and degree, it would have to be, I would suspect, a pretty high level of abuse to reach the level of violence. Can I? No. That's all I need to say. I'm conscious of overstepping my time. Unless there's anything else I can assist the court with.
Thank you very much indeed.
Well, can I just deal with the point your Lordship asked me about whether there was any order making power in relation to the grounds of possession?
Yes.
And there is not an order making power that allows the extension of the grounds of possession.
Thank you very much. Well, we're extremely grateful to Council for all they've said and written to assist us, but also for sitting an hour earlier than is usual to accommodate us. We're extremely grateful.
Thank you.
We will take time to consider our decision.